If it please, my lord, I and Mr. Lutuwe still appear on behalf of the state in this matter.
As the court pleases, my lord, I appeal on behalf of Article 7, 8, 9, 23, 25, 26, 27, and 28, standing in for Mr. Shuudifonya, who's person with submissions next door on behalf of Appeals number 5, 10, 12, 13, and 14. As the court pleases.
Yeah. Mr. Gustavo, you are here?
My lord, yesterday we were served with a medical certificate that is admitted at Mediclinic. It was left at our reception. I don't know who brought it, but I have a copy here to tender to court, my lord.
Well, I don't need it. It's common cause. Is it disputed?
As the court pleases, my lord.
Is there any indication when it's likely to be out?
The certificate simply says he has been detained since the 19th of February until further notice.
That's it. Which clinic?
Mediclinic.
Yes. I saw Mr. Hatuikulipi were rising.
Yes.
Mm-hmm. Oh, you were rising to indicate that you are present?
I was trying to indicate that I'm present.
Oh, yes. All right. So Mr. James Hatuikulipi is here. Then Mr. Shanghala. Mr. Esau.
In attendance.
Yes. Mr. Mwatelulo.
Here, Judge.
Yes. Everyone else is represented, isn't it? Yes. Yes, Mr. Marundeze. Can we recap from where we left?
Yes, my lord. The court instructed the state to get in further instructions on the issue of Section 26 and whether there's any other way the state can reach an amicable arrangement with the accused persons for the access of their legal fees. My lord, to answer any questions on that issue, the Prosecutor General is in attendance on that issue of the points which are raised by the court on our last sitting, my lord. If the court needs any clarification, answer any questions, the Prosecutor General is available to answer any questions on that subject.
Yeah, I don't know what I need to ask, but you being the prosecutor, Section 26 requires what? If we go to Section 26 of POCA,
My lord, Section 26 requires that when an accused person who needs assistance in legal expenses and is unable to fund these legal expenses from any other source should approach the court through an affidavit application to ask for the money to be paid from the frozen assets.
These assets are his, or purportedly his.
My Lord, the assets would have been seized from his, then they're being held pursuant to a court order.
Yes, but I'm saying those assets are supposed to be his, unless proven otherwise, isn't it?
Yes, my Lord. But in this case, my Lord, the provisional order has been made final, so they're no longer vested in his control, but in control of the Curator bonus. So, legally speaking, they're no longer his assets. He cannot deal with them as he pleases.
Yes, I understand that. When the restraint order is made, it is made against what are his assets or purportedly his, isn't it?
Yes.
Does it exclude any of his properties that are known to the state?
No. All the properties which are known to the state should be frozen, and that is why when one is bringing an application in terms of Section 26, he must be candid with the court and disclose all the assets to the court, even those which are not known to the state should be disclosed when one is applying for Section 26 assistance. Like in the present court, my Lord, if I may hasten to add that there are some assets in respect of accused number 2. There are some assets which are in South Africa, and which assets he has continued to deal with as he pleases during the operation of the provisional order and of the final order.
So why does the state not restrain those assets if it knows he has certain other assets?
My Lord, the position is that South Africa cannot enforce our order because the accused persons have appealed against that order. They can only freeze them once the matter has been finalized. Once the appeal suspends the operation of the provisional order. So they cannot, as a matter of fact, freeze those assets.
All right, just for my edification, the accused have appealed against what order?
The preservation order. The restraint order, my Lord. If point of correction, the restraint order.
When was that?
If I may just check with the dates, my Lord.
By accused, we are talking of accused number 2.
All the accused persons.
When did they make their appeal against that restraint order?
If the court may bear with me, I'm checking the date, my Lord.
If any of the accused are aware, Mr. Engelbrecht, do you know?
I'm not in a position.
Any of the accused know when they when they appealed against this restraint order?
The restraint order was initially made on the 13th of November 2020. It was confirmed in May 19th, 2024. And therefore an appeal would have to be within the DS, that's the 14 days. It was done within those 14 days.
In 2024?
Yes.
When about?
It was confirmed on the 19th of May. So within 14 days, and it is pending before the Supreme Court. Judge, I also want to correct Mr. Marandeze. It is not all the accused persons who have appealed, because not all the accused persons are subject to the POCA restraint. So I can speak for myself, accused 3, accused 2, and accused 6, that we have appealed, and that appeal is pending before the Supreme Court. In fact, to make it clear, there are 2 appeals in respect of the POCA pending before the Supreme Court. There was a constitutionality case brought. We lost it before the full court of the High Court. It is pending. Also pending is what I had earlier indicated, the confirmation of the restraint itself. There's a distinction between a restraint and a preservation. I won't get into that, but it's a restraint. The effect is that the assets remain the owner's assets, but the owner cannot deal with them. It is not that they become owned by the state. If that were the case, and that is the point that we made in the constitutional matter, is that the presumption of innocence is negated. Because if you restrain and by that virtue you own them, then I've already been convicted. What's the purpose of this charade?
Yeah, okay, thanks for that clarification. So, if it is correct that the appeal was the latest in about June of 2024, the appeal against both decisions of the High Court on the constitutionality, I assume it's constitutionality of Section 26.
Yes, the appeal was noted, my lord.
I'm saying there are 2 appeals. He says there are 2 appeals, one in respect of the restraint order and the other in respect of a constitutional issue that had been raised. I would assume it's a constitutional challenge to Section 26, is it?
That's correct, my lord.
So there are those 2 appeals pending.
Pardon, my lord?
There are those 2 appeals pending.
Yes, my lord.
Any idea when they are likely to be disposed of?
The only appeal which the state has an idea when it will be disposed of is the one which was made by the state against the order which was granted in favor of Mr. Esau.
No. Let's deal with this one first.
Those ones have not been set down, my lord.
My apologies, Judge.
Yes?
I'd just like to correct the date the POCA restraint was confirmed. I said 19th May 2024. That is incorrect. It's actually 17 May 2023.
17 May.
2023.
Do you have a problem with that, the state?
No, my lord.
So from 7 May 2023, that appeal has not been heard.
The appeal has been filed by the appellants, not by the state.
It has not been heard.
Yes.
All right. And the other one, we don't know when it was also made, but it has not been heard.
Yes, my lord. But my lord, if I may add that where an appellant feels that the matter needs to urgent attention, it's open to the appellant to make an application to the Supreme Court for expedited hearing, like what the state has done in the matter between the state and Mr. Esau.
Yes, I take that point. Yes. But it's neither here nor there when we objectively look at the time from when the appeal was noted and when it is to be heard. And as you have said, you can't even say when it is likely to be disposed of. And
the court should take judicial notice that there's a backlog at the Supreme Court. It's only matters of if there's no such application for expedited hearing, it's matters appeals which were filed. Like I got a notice of set down for an appeal which I filed during the year 2021. The matter is likely to be heard in July.
Okay, so these 2 appeals have not yet been heard, isn't it?
Yes.
Now let's go to the one you wanted to mention.
My Lord, an application, yes, the state made an application in the Supreme Court. Is indicated now that the state has to file its heads of arguments on or before the 10th of March, 2025.
When was Mr. Esau's appeal lodged?
I think it was lodged in, I forgot the notice of appeal, but Mr. Esau can correct me. It was lodged in November 2024.
And you are saying it's likely to be heard when in March?
The heads of arguments, the directive has been given by Supreme Court that the state should file its heads of arguments on or before the 10th of March. So the matter is likely to be heard during the course of this first term.
In March?
Yes. That's a directive that heads of arguments should be filed by March.
No, I'm asking your knowledge of the court procedures. Is it likely to be heard in March?
Most likely, my Lord.
All right.
Because the letter says that the dates of hearing will be communicated, but heads of arguments have been given the deadline to file.
And this is the matter where Mr. Esau had succeeded in the High Court?
Yes.
And the decision is appealed?
Yes.
On some grounds, isn't it?
No, not on some grounds, my Lord. Mm-hmm. But on grounds which the state believes are valid grounds of appeal.
Yeah, on some grounds which the state believes are valid.
Yes.
Yeah. All right. So that is likely to be disposed of in March. Now, any other case related to this trial which is in the courts, let's just go through them.
My Lord, this is for Mr. Shanghala to tell the court, but as far as I know, Mr. Shanghala has about 2 applications or 3 which are pending involving this matter. One is for the disqualification of this honorable court.
Let's just go through them. Other matters. Yes, a disqualification application. Any knowledge of how far that one has gone?
No, my Lord. The state has no knowledge. But last time, Mr. Shanghala will answer that one.
No, I don't want him to answer. You are the state. Are you not involved in this matter?
The state, the state is per se not involved in that matter, my Lord. No order has been sought against the state in that matter, and although the state has been cited as a party, no order is being sought against the prosecution, nor is he seeking the stay of prosecution of this case pending the finalization of that matter. He is not doing that.
Yeah, that I understand, but the state is not involved. That is, it's not filing any papers or anything.
No, my Lord.
So do you know where it is now? How far it has gone?
The last time, from what Mr. Shanghala addressed court, I heard him talking about March this year, some date in March this year.
All right, I'll come back on that one. Then any other? Is there? Yeah.
The other application, which is pending, is where the accused persons led by Mr. Shanghala are seeking the renovation of the dock. So that they can sit comfortably there.
Yes.
That's one which I know is pending.
How far is it now?
According to Mr. Shanghala, is that I think they are waiting judgment on that matter, which will be delivered. I think he indicated again maybe this March, this in March as well.
Yes, another matter again.
No other matter which the state is aware about, although there were some initiations that some applications will be filed, but those are not yet filed. So there's nothing else which is pending before this court, before the courts.
I remember at some time, Mr. Accused number 10.
Oh, okay. Not forgetting that. That one is also when he's applying for review of the charges against him. The judgment, that matter is postponed for judgment. I think Van Wyk can correct me there. I think in July.
Judgment is
in March. This.
Yes,
my lord. Please, the court. If I may just correct my learned colleague, that matter that he's referring to is appearing on the 25th of March.
For hearing?
No, for judgment. May I please the court?
And this one might have the effect of his discharge.
Possibly, my lord. May I please the court?
Any other matter to anyone's knowledge which is still in the courts?
Those are the ones which the state is aware of, my lord.
So, of these matters, which of them have a very significant impact on these proceedings? We have discussed the accused 10's application for review. It would have a significant impact on these proceedings, isn't it?
Yes.
Assuming he succeeded.
Yes.
And assuming the state does not appeal, or it appeals and it still fails.
Anything can happen, my lord.
So that one would have a very significant effect on these proceedings insofar as the accused 10 is concerned, isn't it?
Yes, my lord.
Why can't it be speeded up?
The what?
This matter.
Which one?
This last matter I'm talking about.
The review. The review are waiting for judgment on the 25th of March. So there's no way now, unless, I don't know how we can tell the judge maybe to...
No. Now that it is there, but I'm talking about from the time that it was filed, knowing how important it is to this case. One would have thought it would have been dealt with as a matter of urgency as well. Now that one, yes, and then the other matter which is an effect, a direct effect, is the one for my disqualification, isn't it?
That's correct, my lord.
And that one we don't even know when it's likely to be heard.
Yes.
And the state can't say, please deal with this matter quickly so that we know where we stand.
The matter is being attended to, my lord, and it's only that the last time I spoke with the counsel was beginning of January, but I was assured that it's getting the agency it deserves.
All right. Just on that point, Mr. Just one clarification from Mr. Shanghala, because when is this disqualification application likely to be disposed of?
Judge, I can't answer that question. It's a very difficult question for me. What I can answer and tell you is that there's a status hearing on the 19th of March. When it will be deposes in the hands of the presiding judge and whatever the future holds in that case.
So we can't say now when it is likely to be disposed of.
I certainly have no hope of it being disposed this year, if you want my view. I don't think it'll be disposed this year.
All right.
Judge, also, just to correct Mr. Marondedze, on the issue of the pending appeals. Those pending appeals have been experiencing spurious objections and complications coming from the Prosecutor General's side. The government attorney purportedly acting, I say purportedly because one day I came here and I said you were being represented by a lawyer. Sometimes lawyers say they represent people, they don't represent people. So apparently representing the PG has been raising technical issues which have been disposed of now by the registrar in the Supreme Court. What we're waiting for now is a notice of set down and indication of when the heads of arguments would be set down or should be filed and set down for the arguments. We have no idea when that will happen. The other case that Mr. Marondedze failed to or forgot to mention was the one where he personally and Mr. Lutubezi appeared before Justice Masuku. It was struck. It has now been re-enrolled. It is pending before Justice Usiku.
Which one is that?
This relates to, I can give you the number if that's what you want.
No, just the subject
matter.
The
subject matter is that the accused people have been separated in the facility, and it makes it difficult for trial preparation. They're kept in a unit where some of them where they have no access to the docket, to their materials to prepare, and only come during the day for limited number of hours. In effect, they have 3 hours of functional time to prepare.
That matter
is being argued.
It's still to be heard or what? How far is it?
It's being argued before Justice Usiku on the 6th of March in the High Court. But that is in relation to an interlocutory raised by the state, and that's not the main merits, so it's still a long way to go.
All right, okay. Now, Mr. Marondedze. If the poker applications fail, right? What is the next option available to accused persons in respect of legal representation? What can they do next? The poker applications have failed.
I'll answer this question, my Lord, but not in a representative capacity of the accused persons. I don't know what they want to do, but it's up to them to do what they want to do. But the option is that if that Section 26 fails, and the first option to them is to represent themselves, if they so wish, and the trial continues.
And the second?
The second option is to exercise what the court has been trying to beat into them without success, to bring the Mulima type of application to those who have applied for legal aid and they failed. And
now,
see, my Lord, the other point which the court should note is that it is not per se that it's only in the criminal trial that the accused persons number 2, 3, and 6 have been appearing without legal representation. In the civil matters, they've been appearing with legal representation and with the instructing counsel and the senior counsel from South Africa. And it has come to the state's attention that there was money to the amount, the tune of $4 million, which was in the Investec account, which was most likely used for the purpose of paying this council. It was 4.7 million, which was in that account during the period when the restraint order was operational. So it seems that they have other assets which are known to the state.
Who by there you mean who?
Accused number 1, and accused number 2, number 3, and number 6, which they can utilize for the paying of their legal fees. So, my Lord, we have proof which will be tendered at the relevant moment, that at the relevant time, that money was withdrawn from the Investec account, and so far that amount has been exhausted, but there still remains 2 properties in South Africa which are in the names of accused number 2, which are valued over $5 million, which they can still, which maybe they may proceed to illegally dispose of as they've done before with the cash which was in the Investec account. So they have options available to them.
The options, isn't that option subsumed under the option that they represent themselves, isn't it?
Yes, madam.
My concern is with the second option. Let's assume they went the Mlima way and they succeeded. That would mean that the taxpayer must pay for their trial, isn't it?
My Lord,
I'm not looking at the reasonableness or otherwise of the law. The law is the law, isn't it?
yes.
My question is, the net result of it is that the taxpayer must pay for their, assuming a court says, you must, the state must pay for their legal representation, having regard to all the factors you have outlined, like the complexity of the case, the number of charges, and so on. If a court were to say, right, the state must provide legal aid or provide legal assistance to them, as was done in Mulima's case, that would mean the taxpayer must pay for them.
My Lord, where the government will source the money, the state is not privy to, my Lord.
No, the government doesn't.
There are relevant departments which deal with that, which we are able to answer that question, like the Director of Legal Aid.
No, but what I'm just saying, it would ultimately be the taxpayer, isn't it?
Presumably, my Lord.
Not presumably. Where else does government get the money except through taxes and it would be the taxpayers' money. But anyway, that apart, but that is what I'm saying. Now, the other, how do you constrain lawyers to represent accused persons in this jurisdiction? How do you ensure that a lawyer, when approached, has no option except to represent the accused? Let's suppose a court order was made the Mlima way, or legal aid was provided. How do you constrain a lawyer to represent an accused person?
My Lord, as far as I'm talking from my experience, there is no way of forcing a lawyer to represent an accused person, my Lord. The lawyer can withdraw at any time and can assume agents at any time. It's up to the lawyer, depending on his relationship with his client.
And we know from what has happened in this matter that some of the lawyers are not willing to represent the accused persons on the rates granted by legal aid, for instance.
My Lord, I previously handed over to this honorable court a court judgment of this honorable court, which says that accused persons should be represented by the lawyers who are available, not those ones who are not available.
But the issue is...
There are lawyers, so many lawyers, my Lord, in this country who will be able to receive a legal aid instruction to represent an accused person.
Can you give us a list of them? because you see, let me put it this way. In these kind of matters, which require legal representation on any commonsensical view of them, in other jurisdictions, the lawyers are on a roster basis. When it is your turn to represent an accused person pro deo, you have to. But of course here, there's no way. And we know one of the issues with some of the lawyers is the rates are too low, even legal aid. We heard Mr. Mwatelulo saying his lawyer, he has been granted legal aid, but he can't find a lawyer.
That particular lawyer, my lord, but like I said, there's so many lawyers on the roster.
But who nominates them? Who nominates them for him?
It's a legal aid. He should simply go to legal aid and says, my lawyer is refused to take the brief. They will find another lawyer for him. There are even in-house lawyers for legal aid who are available.
So lawyers will always be found?
Yes, my lord. Lawyers are so many in this country. And there are so many who will be so glad to get the instruction from legal aid to take up this case.
Right, since the PG is here, is there anything you would want to say? I mean to the PG, I'm addressing the PG.
Okay,
in respect of these issues. The way I see it is that there are so many things that have to be attended between now and the date on which there is a general understanding this case must resume, that is the 4th of August. You can comment on anything. I didn't invite you, but since you are here, you can comment on any of these issues, particularly the dichotomy. For me, they got dichotomy between refusing a taxpayer to negotiate, reach an amicable solution, require people to do something so that amicably you can release portion of their assets to represent for legal representation, and the fact that ultimately it might be that the taxpayer must take up that bill on their behalf if the court goes the Mlima way.
Thank you very much, Your Lordship, for giving me an opportunity to address you, especially on that issue of legal representation. My Lord, if it can be noted, last year I took an initiative to engage the accused persons at prison in order to find out what are really the issues and how could the state assist in the process and ensure that the accused persons are represented during their trials. It was only we agreed that I should give feedback to them after the meeting. But before I went back to them, I was served with court applications, which means that they were not inclined to be assisted. I'm speaking especially to the accused who are unrepresented, Sakeus Shanghala, and James. After I was served with the applications, I was in dilemma whether to proceed with the engagement or I should end there, because if I engaged and I have to respond to the issues they have raised in their applications, it might not be fruitful. I then stopped engaging them. I remember meeting Saki after he had served me with the documents at the Magistrate Court, Rudary Streets in Window. And then he was saying, are you going to respond to my letter? I said, I have to respond to the allegations you are making in your affidavit.
Right. Before you proceed, do you share the view which has been placed before me by the state prosecutors that in order for this case to be handled properly, all accused persons must be represented? In other words, looking at the complexity of the charges, and we are talking of no less than 42 main charges and alternative charges, and we are looking, I think, from what I have so far, over 300 witnesses, isn't it? In your view, is this the kind of case which, unless all avenues have been closed, can be heard with accused persons representing themselves and the entities in which they have an interest?
Your Lordship, it's very difficult for an individual to judge the minds of another individual. As a prosecutor general, I have dealt with a number of letters, even from the inmates. I have dealt with a number of cases in which accused persons who are representing themselves are doing better than admitted legal practitioners. And therefore, it depends on an individual.
Yeah, but I'm just looking at the general picture. I'm not saying that you are wrong, because I also, my experience is that sometimes those who represent themselves tend to go straight to the point, tell the truth, and the matter is done quickly, without sometimes too much of legalese, which we sometimes get from lawyers. But that may be so. But we are looking at a specific case here. I'm inviting you to simply say whether you think this is a case which would be easy, even for this court, to manage, to handle, when you are looking at 300 witnesses, self-acting accused persons, complex charges, 42 of them. What is your honest view about that? I know, yes, some individuals can represent themselves competently, but we are just looking at the general picture which emerges from this kind of case.
I'm also familiar, my Lordship, with the facts of this case, and looking at the content of the information in the docket. To me, this case is not complex. Mm-hmm. It's not complex. It's a case which depends on documentary evidence. And therefore, in my view, if an accused person doesn't want to be represented, the accused is capable or able to represent himself. And I also know the duty of the court when it comes to the unrepresented accused person. I just want to add something and make it clear, Your Lordship. When we were posing questions to Advocate Marandoze regarding the state vis-a-vis the asset restraint, we are dealing with the two distinct matters here. We are dealing with a criminal case which is pending before a criminal court, and we are dealing with a civil court which is ceased to deal with restraint application, and that is the court which has granted the restraint order. Now, when the restraint order was granted, there are no longer under the Prosecutor General's watch. I'm just there as a party, like any other party to the proceedings. The court has appointed the curator bonus, and those are the people who are handling the property restraint on behalf of the court. Therefore, as the Prosecutor General, I have no mandate to deal with the restrained assets.
So when they make their application for release of part of their assets, who is the respondent in that case?
The respondent is the state, because we have to respond to some issues. We are just looking at the disclosure,
yes,
whether
I understand,
they have complied with Section 26.
The respondent who is cited by the accused persons in that application is the state, isn't it?
Yes.
Which means in reality, the PG or the AG, I don't know who of the two, but it is the state. And it is the state represented by one or other of the two who are able to say, yes, we have received this application, we consider there is can you be clear on this other point? And as we discussed with Ms. Marondeze, depending on the nature of the application and how satisfied you are with it, you might not even oppose, isn't it? If it is a proper application.
If it's the proper application, the state will submit its views.
I'm saying, being direct, you may not even oppose if it is a satisfactory application as far as you are concerned.
It's very difficult, Your Lordship, to say yes, just yes,
at the theoretical
without
level,
knowing what is the content of the information.
No, I'm saying at the theoretical level, if you receive an application which doesn't pose any issues for you, which doesn't give you any ground to oppose it, you would ordinarily not oppose it, isn't it?
If there is no need, I can't oppose.
Yes.
And then the court will then order, not myself, but order the curator who have the assets.
Oh, yeah, that goes
Yes.
without saying.
Yes, that is the reason why I'm saying the assets is not under me. And the
No. The assets are not under you, and they need not be under you. The only point is when the accused persons are applying for release of portion of their assets under Section 26, isn't it? Mm-hmm. They ask you. They make an application citing you as the respondent, isn't it?
Yes.
On behalf of the state.
Yes.
And you as the respondent is within your power, depending on what the papers disclose to you, to oppose or not to oppose, isn't it?
Yes.
Yes.
But when you look at this case, the current case we are dealing with, the accused persons who are alleging that they need legal expenses are the same people who don't want to become truthful and honest and disclose the information to court. And I just want also to remind them, while I have this opportunity, that if you don't disclose, you make misrepresentations to court, you are actually committing a crime in terms of the Prevention of Organized Crime Act. Even Mr. Shanghala, Your Lordship, it's under investigation. We are pursuing the investigations in that matter. He got the money from the pension fund.
Well, I don't think we need to go into that detail. I think your point is made that in terms of Section 26, they are required to disclose all their assets, isn't it, and liabilities,
yes,
and so on.
they haven't disclosed the assets or the assets they have.
Yeah, but that of course may be your position, but that is for the court dealing with the application to finally decide, isn't it?
Yes, Your Lordship, but I thought the Lordship needs the information.
Yeah, to some extent. My whole point is this. You are aware that the state and the represented accused, through their lawyers, have agreed that this matter can only proceed on 4 August 2025. Are you aware that there has been that understanding between the state, Mr. Samherji, Mr. Engelbrecht, and the accused they represent?
Yes, I was informed by the prosecutors representing the state in this matter, but it's to me, it's not clear why the case have to be adjourned. Because
no, I'm putting it to you. I have said it is you, the state, and the other side, who through some consultation with the registrar ultimately said that this matter will resume in August, on the 4th.
I'm not aware.
Well, do you have any one of you with that?
That the case is
the status report, please.
For trial.
You have the status report here with you.
My Lord, I have an electronic version.
Got the maybe avail it to the PG, please. You can just look at the introductory part of it. May I have a copy? I don't have mine here with me.
I will provide the copy of mine.
Yes. Particularly paragraph 3 and 4, where the dates are given there. You can see that this is an agreement between, or this is the understanding between the state and the persons represented by Mr. Bukes, Mr. Samherji, and Mr. Engelbrecht. That they propose that this matter begins on the 4th of August through to, initially I suppose, through to 8 December 2026 on a 2-weekly basis.
Your Lordship, I'm just being also informed now by my learned colleague here, the prosecutor, that the reason is that the defense lawyers are not available for earlier dates.
So the position here is that if defense lawyers say we are not available until 2027, what do you do?
What I know, Your Lordship, through my practice, it's that it's not parties who can decide when the court should sit. It's the court who should make it available. If the court is available, then parties should make themselves available.
Yeah, but how do you secure that? Because my experience in the jurisdictions I've served, isn't it? Before the beginning of every year, there's what we call a criminal court roll.
Yes.
Which indicates to the parties exactly when their matter is going to start. And that is not made by the judge. The judge is called, there's a criminal matter in court number 7 starting on the 7th, and the judge walks in there and he starts the criminal trial. So apparently with that criminal court roll, everyone facing a criminal charge will know in advance that on 12th August, my case is coming up. On January 10, 2026, my case is coming up. And usually they would have been given adequate time to prepare themselves and so on and so on. But anyway, the court, I am ready. How do we deal with it, PG? I'm ready now. I'm ready to proceed. The lawyers are not ready. The state is saying, well, we can, we understand that the lawyers are not ready until August. What does the judge do?
What I know, and what I know my instructions is that when the court is ready, prosecution always have to be ready. And if there is a prosecutor who is not available, another prosecutor will take over. And it's what I know from how the High Court in Namibia has been practicing. And that is the reason why the pre-conferences proceedings were initiated. It's to deal with all the preliminary issues. And when the case is set for trial, we mean trial.
So this case was set for trial 2 October 2023. That's when it should have started.
That is the reason why I went to the prisons to find out what is really going on. Otherwise, I think to me, either what is happening is tactics to delay the starting of the trial. Why I'm saying so, Your Lordship, especially in the case of Saki. Yes, he's saying he needs legal representation, but he has not brought an application before a competent court to request for assistance to pay his lawyers. And it has not, he has not filed any application.
What do you think about the time period from now to August the 4th? Do you consider that it is reasonable for most of these cases we have been talking about, have been disposed of? Is that reasonable time for accused persons to have put in place some form of legal representation for themselves if they can? Is that reasonable time? Because my intention is this. If we fix, as is the general drift here, the 4th of August as the date of trial, the trial will start whether or not any of the accused persons have legal representation, and they will have to represent themselves. In other words, my question is simply, is it a reasonable period having regard to all that we have discussed for the trial to start?
To me, it's unreasonable. And I can attest here, Your Lordship, that I'm available for consultation of all the parties involved to ensure that any outstanding issues is dealt with amicably, and the trial starts within a reasonable time.
Right. You are now aware, obviously, of what the outstanding issues are,
Yes.
isn't it? It's mainly legal representation
Yes.
for at least 4 of the accused. That is Mr. Gustavo, Mr. Shanghala, James, Mr. James Hatuikulipi, Mr. Shanghala, and Mr. Mwatelulo. The 4 of them. This court or this judge, when things are in order, I can start next week. If your consultations are completed and everything is in order as far as all concerned are concerned also, I'm ready to start. So it is heartening that you are saying you are available for any consultation so that we speed up the matter. Now, that would include consultation with these other lawyers.
Yes.
Who are not available until August. You see, the court in this jurisdiction can be placed in a very invidious position. If I say we start tomorrow, the lawyers will say I'm not there. Short of finding them in contempt, what do I do? The lawyers will say I have a pre-scheduled hearing of this matter and that matter and that matter. I'm not available. And the state, as it has been doing, it also says, oh, okay. Then the judge is left high and dry.
I fully agree with you.
Right. So,
Judge. And,
can it be our understanding, because the outcome of your wide consultations to see that the matter must proceed, isn't it?
Yes.
Could result in an earlier date of hearing, which, if agreed, would mean that I would have to be back before the 4th of November. And those consultations might also extend to some of the cases before the courts, isn't it?
Yes.
For instance, Mr. Esau's appeal, it could be part of the consultation, and then availability of funds in the event that these restraint orders are not partially lifted. Because in the end, we can't lead accused person on the garden path to say, oh, the consultations can result in some understanding, and they don't make the Mulima type of application hoping the consultations will succeed, and then again you come December, they say, no, we were pursuing these consultations, and we still haven't applied the Mulima way. But the point is, August the 4th is a date beyond which I don't think we can go without commencing this trial. It is unfair to accused persons who are in custody. It is unfair to those accused persons who are ready to proceed. It is unfair to the whole judicial system.
And the state also.
And the state. Unless you have anything else you would wish to say. But if I get your nod that, well, August 4 is reasonable time within which all these things can be looked at and the trial starts in earnest.
Maybe just to end, Your Lordship, to say that even the issues of the rate which the defense lawyers were talking about, I did actually already started looking into that. As I said, my efforts were then stopped of the applications which were brought up and I was cited, and I was in dilemma. I'm ready to pursue such engagement and see that we get a solution. And I'm just urging all the parties to these proceedings, the accused persons and the lawyers representing some of the accused persons who have lawyers, to be cooperative and work together to get an amicable solution. Is it pleases you, Your Lordship?
In the position you are in, you are more or less in the position of a judge. Doesn't matter what the parties do, you can't afford to be angry. If we did ourselves, things would not work. So when you are pursuing something which you must pursue, just pursue it. Even if people want to put spanners, the courts and the certain functionaries can't afford to say, I give up because you've done that. You can't afford to be angry. We don't get angry. We can feel a bit disturbed, but I never get angry. I just say it's your right to say what you want. But it's my power to decide what I must decide.
I didn't get angry. I just thought, even if I get responses, how will I communicate it to the other side? Because you might be misquoted or whatever. And then I said, let me pack it for a while. But I'm ready. Thank you.
I think we've discussed enough. The point, the one point about this program, I have a prior commitment in October. That is October. Even if we were to go by the agreed dates, October I won't be available. That is, if we adjourn on the 19th of September, we would only be able to resume on the 27th of October, which would give you about a month of freedom from this case. Right. The other point I wanted assurance on, Mr. Siomunji and Mr. Engelbrecht and the accused persons, relates to the responses to the pre-trial memorandum. I want the final position of the parties.
May it please the court. My lord, with regard to accused 5, 10, 12, 13, and 14, whom I'm representing, my lord, we see no need to reply to state's pre-trial memo, considering the fact that the pleas were already taken. And secondly, your lordship, we stand by the dates indicated in the status report. I believe it's of 31st of January this year, the same status report that your lordship has been referring to. We stand by those dates. And just to add that, your lordship, as a legal practitioner, I am available, but only when it is permissible. I'm emphasizing when it's permissible because there's other cases that were agreed beforehand. And that is why when we sat, we agreed on the dates as indicated in the status report that is commencing from 4th of August. So that agreement is not based on the fact that we do not want to start. If we didn't have prior commitments, we would be ready to start even next week, like your lordship indicated. But there's prior cases, also high court cases, which were agreed before. So that is the only reason, your lordship, from my side, that we can't start earlier than the agreed date of 4th of August.
And the issue of plea explanation?
My Lord, we will not give any plea explanation. So the state will be put to the proof of each and every allegation.
Now, in England and elsewhere, this is just by way of looking at how you can curtail proceedings. In England and elsewhere, you are aware that there is a requirement for filing a defense outline.
Indeed so, my Lord.
That tends to speed up the trial, isn't it?
Indeed so, my Lord.
It is not the practice in this jurisdiction.
No, my Lord, not according to the Criminal Procedure Act 51 of 1977 as amended.
Do you think it should be amended accordingly?
Well, if and...
Let me tell you, I have had many cases.
Your Lordship.
In many cases, especially if you look at murder cases, right? You can go on for a month trying to prove the actus reus, isn't it?
Yes, Your Lordship.
Only for the defendant to say, I was acting in self-defense, or I was acting under provocation. After I spent a month leading evidence to show that the person did it, and that is not his defense, that I didn't do it. His defense is, look, I was provoked, or I was acting in self-defense. That means there was no need for you to spend all the time you spent on proving the actus reus, isn't it?
Indeed so, Your Lordship. In that circumstance, yes.
What I'm simply saying is that could be another area of consultation between you and the PG. If you agree that you can file a defense outline, well and good. These proceedings will be curtailed very significantly.
I agree, Your Lordship. There's still room for that. I mean,
yes, I would be happy if you visited that area, whether any defense outline can be filed, and I would be happier if the state, if the legislature would amend the law along what is done in England, in all other jurisdictions, some of which you don't want us to mention. But a defense outline does curtail proceedings by far. Anyway, so I agree, I would urge you to look into that with the other side to see whether you can file a defense outline, and then the trial focuses on what are disputed issues.
May it please the court.
As the court pleases. My Lord, I'm only here today to confine me to the issues as set out.
Just a minute.
I beg your pardon?
Just a minute. Yes, Mr. Engelbrecht.
As the court pleases. My Lord, as I have said, I'm only here to answer questions as far as the court order 11 February 2025. The first question is whether or not we will give a plea explanation, and that answer is no. We remain silent and put the state to prove all the elements of the crime. So therefore, there would be no plea explanation forthcoming on behalf of my clients. The second issue, whether or not we will answer questions to the pre-trial memorandum of the state, that answer is also no, because that issue should have been dealt with before the commencement of the trial. But what we intend to do is that indeed there are certain issues that will become apparent and disputed during the trial, and that will also call upon the court in order to go into a trial within a trial. So what we intend to do as far as that issue is concerned, we will inform all the parties in advance what would become issues of dispute in order for all the parties to know where we are coming from and what will then be issues more pertaining to the admissibility thereof. But that we intend to file such, let's say in the next 3 weeks, in order for the court as well as the state to take note of.
Can I just make sure I understand, what is it you intend to file?
What we intend to file is that what will become disputed during the trial.
You intend to file
a notice
of
all the issues that we will challenge, the admissibility thereof.
all the issues that you will challenge?
On the admissibility thereof. Because when it comes to issues of admissibility, then there's an issue whether or not, or when there's issues of admissibility, there would then be an order, trial within a trial. In order for all the parties, the court as well as the state, to know what we are challenging when it comes to the admissibility. We are not giving notice that we will file issues, challenge issues on factual issues that can be dealt with during the trial.
Well, I assume that is the kind of notice we'll have to deal with when it is filed.
Indeed, sir. And that, as far as the date is concerned, in fact, there was a meeting by the parties that have, let's say, attend to that meeting. Although I was not in agreement as far as certain of the dates is concerned, we then agree, all the parties, as far as the availability is concerned, that this trial must commence on the 4th of August. And if I may suggest, I have listened to concerns, I've listened to challenges, I've listened to what is still outstanding. So what I would then suggest is that maybe perhaps the court must, and it's only a suggestion from my side, I'm not dictating anything, that maybe perhaps the court must postpone the matter until such time or during this time from now up to August in order to manage what is still outstanding. Because when we reach 4th of August, that all these preliminary issues to be resolved at that particular point in time, that we can just commence with the trial on the 4th of August.
Yeah, well,
because, my Lord, if the court postponed this matter and we come back on the 4th of August, I just hope that that would not be the case. But if we come back on the 4th of August, just to be informed that we are still waiting for the Supreme Court in order to rule on certain issues, or if I have not yet applied for legal aid, there's no application in order for the court to issue a certificate for lawyers to be appointed. And if we wait until the 11th hour, and such applications is then before this court, then the lawyers that maybe perhaps they've been appointed at the time have already put a matter set down in the diaries, and then there's another obstacle. So maybe perhaps that is my only suggestion, that the court manage these issues mainly on a monthly basis in order for us to resolve all outstanding issues before the 4th of August.
It would appear to be the way to go. But I am persuaded more to the view that the 4th of August is the day the trial will begin. And it gives the parties, is it not more than 6 months? We know what the real problem here is. It's legal representation. And when come the 4th of August, the position I take is the trial must proceed with those who have failed to secure legal representation of their choice, representing themselves. Because we can't go on and on about legal representation. There is a limit to which that right, in my view, can be allowed to be exercised. If you fail for one reason or another, you ultimately must just represent yourself.
My Lord, I take note of that. More particular Article 22 in case law that follows from that right is not absolute. What I'm trying to say is that all the issues, it is indeed intertwined with the issue whether or not we will be ready on that day. And that is the only reason that I have suggested as far as the managing of this particular matter. But at the end of the day, the court is the one that must decide. But as I have stated, that I hope that that day we will be ready to commence with this matter, as the court pleases.
Yes. Now, Mr. Shanghala, if you are speaking for others.
Thank you. I note that you have dealt, the way in which you've addressed the issues in the court order, you dealt with item C, the legal representation first, and then went to part A and B later. I also just want to record that I only got this court order today, even though I pleaded with you last time that we get the court order detailed as it is. I only got it today. Nonetheless, I'd like to address three issues. One, I'd like to just make corrections in law, that we are all agreed that this is the law and not what was stated. Two, I'd like to respond to some of the issues that were said, which I think is only fair that I've been allowed to respond. And then three, address the issues that as they are in the court order. The first issue, Judge, is this. There is no court today, particularly the High Court, there's no High Court pending matter relating to POCA. The POCA order, when it was granted on the 17th of May 2023, is final. It's no longer interim, it's a final restraint order. It's done there. Only thing pending is the appeal. So there's no pendency of a court order that would vitiate a prosecutor general application elsewhere. The problem, and this is point number two, is this.
What is the first point?
The point is there's no pending High Court POCA matter. It was made, if you find the time and get into the record, one of the PG's presentations here is that there's pendency of POCA. There's no pendency.
The issues we have talked about with respect to POCA, which is pending in the courts, isn't it? Is your constitutional application, isn't it?
Yes, these are two different things that I'm trying to say.
Yeah, let's be clear what you are saying, because I need to follow you.
What has been expressed by the PG is a position that she's expressing in the Supreme Court, that the granting on 17 May 2023 of the restraint order is not final. That until, this is what the PG, you can shake your head, but this is what the PG has put in her papers, that until a conviction is made or an acquittal is made, it's sort of pending. It's not. It's a final restraint order and it's done. What is pending is in the Supreme Court are appeals. It's just a correction. It's a position that her papers indicate it is not the law.
You know, on your side, I'm more interested to know whether you will file a Section 26, you and the Mr. Hatuikulipi and Mwatelulo.
I'm getting there, Judge. I said I'm getting there. I'm going to systematically deal with these issues, so that, and you'll find the reason in it why I'm starting here. Secondly, the PG has, and the court order here, granted by this court or any other court for that matter, has no extraterritorial applicability. Right? It's law 101. Has no extraterritorial applicability, whatever anybody may desire. So,
what do you mean?
Property in South Africa is not the subject of a court order of the Republic of Namibia in the Republic of South Africa, unless a certain process is engaged.
No, I thought you were talking about orders generally, because there can be reciprocal enforcement of court orders.
That is, now you're talking to what I'm talking to, a process to make it reciprocal. It is not automatic. We are no longer in Southwest Africa, the Republic of South
That
Africa.
is, everyone knows that, I assume.
No, that is why I'm trying to say to you, certain things that have been said to you here are not relevant for this court, for instance. Whether or not accused 2 has property in South Africa is neither here nor there, because they are not engaged, they are not before the courts in South Africa seeking that property to be restrained.
No.
Yes.
We don't want to get into a legal argument. The point about poker is to say disclose all your assets so that we are satisfied you have no other means of funds.
Judge, I'm getting there.
No.
I'm getting there.
Let's not get bogged down on issues.
No, Judge, I'm getting there. I was just stating the law.
Are you going to listen to me?
I was hoping you were giving me an opportunity to listen to me.
Now, what I'm saying, let's not spend time on what is common cause.
I'm happy it's common
The
cause.
law is understood by yourself, by everyone else. Let's not spend time on that.
I'll move on.
Let's just go to the points that matter. For me, that is why I asked the question. Do you contemplate filing a Section 26 application?
Judge, I will answer that. I indicated to you exactly how I'm going to go about these issues. Just permit me, I beg you, just allow me, there's a means, there's a reason to the order that I'm taking.
No, Mr. Shanghala.
Now you've indicated.
No, please. I have control of these proceedings, right? I will ask my questions, you answer them. If I give you an opportunity to expound, you do so. But when I ask you a question like, do you intend to file a Section 26 application between now and August, I expect you to say either you will, you intend to, or you don't.
Before I answer, Judge, may I just record how I feel about how you are approaching this? I think it is a bit unfair. I'd indicated to you exactly how I'm going to respond, and I thought it would be understood. I would highlight the issues, and I'm happy you say it's common cause. I was moving on to the opportunity just to respond to, I think, which is unfair. Things have been said, things must be corrected, or at least you hear my view. For whatever measure, it doesn't mean you're going to rule on it, but just for fairness. But if you do not want me to respond, that is fine. I will now respond to your question particularly. It was going to be answered particularly by the response that you do not want me to give you. Yes, we do intend to, but our understanding of the law is this. Section 26 requires that you make a full disclosure. An application was done by accused 2. Why the court declined to grant him access to his funds so that he may pay for his legal fees is because the court says he did not make a full disclosure as to his liabilities. To determine those liabilities, and I sound like a broken record, you've heard this before, I'm going to repeat it. The curator must be engaged, who is vested with our estates, so that the curator can bring the tax liabilities up to speed so that an application can be made which is fully disclosed. But we can't get to the curators now, and you know why. We've said this to you ad nauseum. Now, honesty. Apparently we must be honest. If we are not honest, you see, Judge, you see, the Prosecutor General, you pointedly asked her, who is the respondent in the Supreme Court? And she says it's the state. It's not true. It's the Prosecutor General. There is a difference between the state and the Prosecutor General. As you would say, it's common cause. I mustn't get into petty issues. But I have the issue here, the appeal that she lodged herself. It says the Prosecutor General, which means it's not representing the state there. It's a civil matter. It's the Prosecutor General, the applicant, initially in the poker restraint. Until the assets are divested by court order, to the extent of apparently enrichment in the corrupt activity or whatever it was that is alleged, they still remain the assets of the individual under the curatorship of the curator. That is just one thing here. So that's the honesty that you get. Anyway, secondly, the application can only be made from my accused three's perspective and from my understanding of the position if I'm making those disclosures and I have actually exhausted the funds which are not restrained. Then I can seek now to get access to those funds which are restrained. But as I indicated, and it has been said by the PG, I've indicated to you before, she says there's no application now. You know exactly why there's no application now. There was a meeting, the PG was represented, the registrar committed to getting back to us, and then the applications will be made. The applications will be made. But to get to a Mulima application, type of Mulima application, it is only when we've exhausted these applications.
Why not two-pronged?
Because sure as the sun will rise, the PG will oppose and say you have not exhausted the previous pending matter. She will. You know that she's opposing a successful grant. She's appealing a successful grant of access to legal fees.
No, but you, as I said before, you can't litigate on the basis that I know that that party is going to do this. You just litigate. You may be surprised that she will, when she sees your papers, she might change her mind.
So, last thing I wanted to indicate is that
can we agree that the Mulima approach and the Section 26 are not mutually exclusive?
Judge, I have cited you case law before, which says you first exhaust your own means before you become a client of the state. I've cited this case for you in the separation of trial. It's there.
Yes.
Yes. So I will not agree with you.
But if you can't get Section 26, have you not exhausted your own sources?
You see, you asked me initially, why can't they be simultaneously launched? And I'm saying to you that you couldn't then have exhausted in the Mulima one if this one is still pending. What if this one is granted before and you are applying here?
All right. Anyway, you are the one who will make these applications. But I would urge you to take a
parallel approach.
Dual approach. Yeah.
Yes.
I would urge you to do that. The choice is yours.
Yes. Judge, you heard from the PG herself. She came to assist us. She denied it in her papers. The application that was before you, by the way, was a separation of trial. And I only applied to supplement the affidavit, to supplement the application for a separation of trial. It was not an independent application. It was only an application to supplement. So the honesty that is coming from the PG, I don't know. But she says that this case is about documentary evidence and that people should represent themselves. Judge, I take Mr. Pius Mwatelulo here.
No, she didn't say you must represent yourself.
No, she said the end of it is that
the matter is not very complex.
It's not complex. We can start tomorrow. People can represent themselves. I've seen people who represent themselves do better than lawyers, etc., etc. That's what she said. Now, I'm taking, for instance, the issue she talks about documentary evidence. We know that there's a new electronic evidence legislation promulgated in the past couple of years. We know that documents don't speak for themselves. Somebody must speak to them. We know there's issues of admissibility, authentication. I wonder whether everybody is as equipped to handle when the documents are being presented. And by the way, we have 165,000 pages disclosed thus far. So I don't know, Judge, if it is fair. It is a fair assessment to say that people can just represent themselves. In this case, I'm talking about this case.
Yeah, all right, but the question still remains, Mr. Shanghala.
Yes.
You go the poker route, you fail. You go legal aid where you fail.
Yes.
You do everything in your power, you fail.
Yes.
What then should happen?
Then what would happen is the court would make a determination to say, from what I see here, This case is complex. I do not believe that a fair trial will ensue if people are not represented. I am therefore ordering pro deo counsel or pro bono counsel. It can be done.
Where will you get the counsel?
There's a registrar of lawyers in this country admitted to practice law, and you direct that 2 or 3 be made available, and they become available.
Are they compellable?
That's what I'm saying. The court order makes them compellable.
So you mean the court order will say, I direct that Mr. Siomuji must represent...
Courts have, in the past, directed that people who are legally admitted, who admitted lawyers, represent people who are not with representation, and it has happened before in this division. It has happened before. Because I'm saying that Mr. Engelbrecht made the point that there's case law to say that this right is not absolute.
My question was, Mr. Shanghala, you've done everything in your power, and you don't succeed. What should happen to your trial?
It's exactly what I answered you. I said, in this case, where the PG in her affidavit says that this case is complex, the court then says, I agree with the PG, this case is complex. If an individual is tried in this case without representation, a fair trial is not likely to ensue. I therefore order that counsel XYZZ.
So the court must merumot direct.
It's enjoined by Article 5. It's not really by application, it's enjoined by Article 5.
Which says?
Which says that you must not only protect, but also respect and protect, but also uphold it. So take positive action. This is why I brought you the case of Luboya before.
Yeah. Well, the point is you are saying the court must merumotu order that you be legally represented on its own initiative.
What I'm saying, Judge, is that at all times, the court is the protector of my rights, even if I'm not aware of them.
Are you saying the court is entitled to make an order?
The court has full powers to do so.
Yes, all right.
Lastly, Judge, it's the issue of the pension fund that was mentioned by the PG. Just want to inform you that I have requested the curators, if they are willing to administer the payment of school fees for my children, if I request the pension fund to make payment into their account, and that is in process. Before the POCA restraint application was made.
Did you notice I stopped there from dealing with that?
Yeah, but to be fair, if you had only heard one view, you've heard now the other view.
I stopped there because I don't think it was very relevant.
It was not relevant at all. It was ad hominem.
So that is why I dissuaded from continuing on that.
But I'm happy it played itself out in the public. We now know. I thought Mr. Marondez was a problem. Anyway, Judge, there are other issues. There are other issues last time that I indicated to you. But before I get there, on the issue of the plea explanation and the pretrial memorandum.
Your Lordship, I don't want to disturb Mr. Shanghala, but I actually have an engagement before your brother, Judge Unengo, next door. If I may kindly be excused.
I thought you'd just do it the way you came in.
Your Lordship, that would be very unbecoming of me as a legal practitioner. I can't do that, Your Lordship.
But I say you walked in, and then I was expecting you. When your time is up, you just walk out.
If I'm permitted, I can do that, but I can't just take the initiative on my own.
Yeah, but earlier on, no one permitted. You just sneaked in.
Mr. Engelbrecht stood in for me, Your Lordship, when he addressed the court.
You will be excused. You want him to be brief.
No, Your Lordship, I don't want to curtail his address. I'm just saying, if I may be excused, I believe I've already given the court input.
Yeah, no, that's all right.
Yes.
You will be excused.
I'm indebted, Your Lordship.
Yes, Judge, I was saying, on the plea explanation in the pretrial memorandum, although the PG today says that it's not a complex matter, we have affidavits where she says it's actually complex. Just based on that alone, I would like to and I think I speak for accused 2 and 6 when I say that we'd like to wait until we have legal representation to be able to entertain the question whether or not we give a plea explanation and whether we answer the pretrial memorandum. At this point in time, it suffices to say that I have no duty to prove myself innocent. Then, Judge, there were issues that, and I'm happy now that the PG is here, maybe she can take note, of disclosure which is incomplete. For instance, in this case, by the way, Judge, I must just give you a prelude to what I'm about to say. This case was consolidated after the state made an application for case CC, criminal case 06-2021, and criminal case 07-2021 to become one. Now, the case 06-2021 in its initial permutation was a case that commenced with the ACC, and it had a reference number, according to the disclosure, ACC ERO-14-001270. It then became CR 659-11-2019. What has not been disclosed is a section 31 of the Anti-Corruption Act, referral to the Prosecutor General, and the same with 07-2021, which started off as ACC HQO-14-001277, which became CR 47802-2020. Those two disclosures have not been made.
Is it common cause that they have not been made?
Well, I've told Mr. Marondeze time and again, I've put it in the status reports. It was put before court, has not been responded to. If they now have it, and if they can direct us to where it is, we'll be happy, because as I said, it's 165,000 pages. Maybe between the 9-10 of us here, someone has missed it, but we haven't seen it.
I mean, that total disclosure will be 165,000 pages.
Yes, Judge. Its size is the length of the height here, from here to there to there. That's another issue, but it's coming. The other undisclosed
my
issue...
question is it commonly agreed? Because with disclosure, I assume that when you ask for certain documents, the state will either say, yes, we make those available, or we object, isn't it?
Yes, Judge. It's either there or it isn't there. I'm saying it's not there. We'll hear from them if they say it's there. And then they can direct it.
What has been the attitude so far to that disclosure?
It's just silence. We requested it. We don't get it. In fact...
And what are the options available to you when the time comes?
To make an application. And I'm saying, is it really necessary? I'm happy that the PG is here so that we can just get a move on it, because as she said, she wants to curtail things so we can start quickly. Yes.
Yes, so no, anyway, I will leave it to the parties if
yes,
they can
Judge.
agree.
The other issue is an appointment letter of the special investigators under Section 14 of the Anti-Corruption Act. It's not disclosed.
For disclosure, can we just leave?
No, well, Judge, I'm doing this specifically so that at least if I just say disclosure, I'm maybe being just vague.
No, what I'm urging you to do is to communicate with the other side that we need disclosure in respect of the following items or issues. If they don't respond, you know what should happen. If they respond and tell you that no, this disclosure is not, we don't agree, or it's irrelevant as far as we are concerned, then you take it up from there. But I'm simply saying, let's leave all disclosure to the parties. Itemize again to them what you need to be disclosed, and if they and see whether you can reach some understanding.
I understand you, Judge. I was just a bit ahead of you. This was the culmination of all the requests. I was now putting it here so that next time I just make an application. But that is taken. They have everything they know we want. The other issue was the pagination of the disclosure. So Last time we were here, you saw that there was a witness in the dock, Dr. Moses Maurihungurire. It took me 2 days to go through and just make sure. I realized that he has 4 statements. In the fish core case, which was now 07-2021, it's A29 and A30. In the Namgomar case, which is 06-2021, then he has A86 and A90. Now, the difficulty I have is that with the disclosure being done here electronically, if I am to go to, if he's testifying, and I want to verify that this is indeed what he said in his statement, to get to the pages, first I don't know, the number of pages. The issue is pagination. I'm sure you understand pagination. So we need to discuss it.
Yeah, discuss.
Yes.
Because I can't imagine anyone writing a document without paginating it. How do you?
165,000 pages.
That's what I'm saying. If you just pile papers together, yes. Who knows whether page 120 is not page 1,000. So that is a matter of organization of paper, isn't it?
Yes.
Of papers to be filed.
An example is when the PG made an application, and not the state, the PG made an application in the poker matter. She paginated the 6,925 pages. I can tell you the number because I went to see the last page. 6,925. So can we get a pagination? The other issue, Judge, relates to, and I was telling you the size of the docket. Where do we keep it? Because we have one bundle that is at the cells there. Not where my co-accused sleep, but where Mr. Esau and Mr. Mwapopi and Mr. Gustavo and I are kept. If we need a document from that disclosure while we are at court, I wonder whether you will be amenable to me being taken there and how long it will take me to go through the ins and outs of that facility.
I don't know what you agreed, Mr. Shanghala. What I know, each accused person is given papers relevant to his case, isn't it? I don't know whether you agreed that each one will be given his docket or each one will I don't know.
No,
what did you agree?
What I'm getting to is this. We need somewhere at this court where there is a room where we can keep the docket. The state would have to give us a docket, complete one, all the 4 disclosures that they made on the 4 occasions that they made, they give it to us, paginate them, and when we are at trial, during the break I can go and access that docket and not need to go to the facility. Secondly, if we get lawyers, and hopefully we are going to get, will require that disclosure, because the only disclosure that was made, yes, I know, it was probably disclosed to previous lawyers, or if I get a lawyer and Mr. Mwatelulo has a lawyer and Mr. Hatuikulipi has a lawyer, these are different lawyers, they'll require disclosure. But the important part is...
What do you mean? If certain documents have been disclosed to your erstwhile lawyer, you will have to retrieve them and give them to your next lawyer.
One disclosure was made to the erstwhile lawyer, or 2 disclosures were made to the erstwhile lawyer. What about if I have counsel now? Must I...
No, disclosure is made to you. All I was saying is if your erstwhile lawyer handled documents on your behalf, he has the documents. If he is no longer representing you, you retrieve your documents and give to your next lawyer.
Why I'm saying this, Judge, is that 165,000 pages, the way it looks is that it requires a pickup, bakkie as we use in the Afrikaans colloquial here, to go and get it. I am not in a position to avail it to my lawyer. Maybe in the hands of the previous lawyer, the one bundle that was for the three of us in our entities, but not all of us received disclosure. Is what I'm trying to say. So we share
a room at the courthouse for.
That's one.
For storage of the disclosed documents.
Yes, and somewhere where I can put them here, those various documents.
Yeah, those logistics you can organize with the other side and the registrar. We need a room. I don't even know how this court is structured to say go and use that room.
No, Judge, I'm not asking you to do an in loco inspection.
No, this is what I'm saying. You discuss all these issues with the relevant parties. You need a room, you need the disclosure, one set of documents for all of you, or each one is own. That is what you discuss with the PG.
Okay. I'm pretty sure that this matter will return at some point because we don't address it. But nonetheless, I move on. Judge, there are matters that can be brought before this court and matters that cannot be brought before this court. I hope we understand that even the issue that we talk about, the Mulima type application, cannot be done in this court.
I don't know.
Well, according to the Supreme Court, in Mulima, they agreed with then legal representative David Smuts, who represented Mulima, that because other persons needed to be cited as parties, such as the director of...
No, that's all right, Mr. Those matters which don't come to me, take them to the right place. Those which come to me, they will come to me.
Yes. So I want us to remain alive to that because it will impact this calendar and the trial issues. So once that is made, it will impact that calendar. That is all I wanted to address, Judge.
How?
Well, I don't suppose then that the judge would say, during the pendency of that Ala Mulima type of application, you will start nonetheless. And then
why not?
that, excuse me?
Why not?
Because then I don't see how you are protecting the rights of that person who's making that application to be represented, which is a right they seek for legal representation protection, when you just start without them being represented. And then a witness goes through, for instance, and something which is perhaps should have been raised by that representative is not raised. So I don't know how that impacts. But we'll deal with that when we arrive at that type of a juncture, I guess. But if the attitude of the court is to say that if I secure a lawyer on the 3rd of August, that lawyer must be prepared for trial on the 4th of August, then, well, maybe we'll hear whether the court will not listen to the reasonable explanations as to why maybe an adjournment is required or not. But as I say, at some point in time, I think the court will have to come to a point where it determines whether in this case, with the facts of this case, the complexity that the PG has indicated and now denounces, whether it will be a fair trial if we are unrepresented. Thank you, Judge.
Mr. Hatuikulipi, do you want to add anything, and Mr. Mwatelulo, before I go to Mr. Esau? Anything you want to say, add to what Mr. Shanghala, if he was speaking for you?
No, Judge.
Okay.
Nothing to add.
All right. Mr. Esau?
Well, thank you very much, Honorable Judge. In terms of the status report, which was availed to myself with a record of a meeting between us and the registrar of the court, Madam Scatterlund. I want to make it very categorically clear that this very record, which was provided to us with a copy of a status report, this record is totally misleading. Because I went through this very report, and I hope at least Honorable Judge must have received this very record as well, with the status report for a schedule of the continuation of trial or the commencement of the trial dated for 4th of August 2025. I am in a very serious predicament placed by the Prosecutor General as an appellant to the judgment of an order of her ladyship, Madam Justice, Mrs. Justice Tejaga. That is placing me in a break because I need legal representation because of the complexity of this very case I'm faced with. Notwithstanding the evidences which they are saying they have, which is also a question of dispute in terms of admissibility of those very evidences, which I can only challenge those ones in defense of those allegations that is made by the Prosecutor General. Now, I am really also in the very same boat as Your Honor, that the trial should start ASAP, as soon as possible. Because having been in detention for more than 5 years and 3-4 months, I think it has become unjust.
But you have no legal representation and you want it.
Sorry, my lord?
You have no legal representation and you still want to secure legal representation.
Correct, my lord. That's why I went for Section 26.
Yes, so now, to say you want it to start as soon as possible, I thought you would say you want your appeal finalized as soon as possible so that you know the position. Because you want legal representation, you can't start now because you are waiting for a decision on your POCA application.
As long as they withdraw this appeal, my lord, then we can start ASAP. Let them withdraw.
The consultation, I think we did touch on that. We touched on that, whether it would be part of the consultation that they persist with the appeal or not, but also with the right, like it happened recently in another jurisdiction, the Court of Appeal or the Supreme Court can say, no, you are not withdrawing that appeal, we will deal with it. So we never know what happens. But nonetheless, if it is capable of resolution between the parties, we leave it to the consultations, which the PG has indicated she is agreeable to.
It's good that I hear that, my lord, that the PG is agreeable for that very.
To consultations, not
for consultations,
yeah.
In line of legal representation, or
yes.
covering my legal expenses by the AG's office, Attorney General. Having said that, my lord, in terms of the order.
Well, I thought she restricted herself to the appeal. If there is going to be any consultations around that subject, but I suppose there can be boundaries to what you consult about. You can consult about anything you want, and if you can agree, all the better.
I am very happy to hear that at least we can consult on any other matters. Having said that, in terms of plea explanations, my lord, I am not in that position to give plea explanations without legal guidance. And Roman 2, pre-trial memorandum, reply. I don't think that I will reply to that pre-trial memorandum of the state, represented by the PG's office. Because I need also guidance in that regard. My position regarding the legal representation as an accused person and the entities which I am representing, my Lord, it's a must for me that I need to have legal representation. Because I'm a layman, I'm not a lawyer, I'm not a lawyer by training. I was a public officer appointed in terms of Article 32 of the Constitution by the appointing authority. That is both the late presidents who appointed me to those positions.
Which late one?
The late Samherji Kaigo. I was also appointed as deputy minister, which they have not even mentioned, by the late whom we are now, Sem Shafishuna Nyoma. So I was also appointed by the old His Excellency Nghipunya Pohamba. So I went through all that very appointment. But what I'm saying that I was a public officer, and I need for sure to be taken care of as a public officer as well. Thank you very much.
Now, Mr. yourself and Mr. Shanghala, speaking for the others, I did ask the question whether you are prepared to consult around the filing of some defense outline. Or you, yes, yourself, what is your attitude towards that?
Filing?
What do you call a defense outline?
Defense. For sure, I will consider that one to see whether I should file or not file. It depends from the means, whether I have the means also to file or to instruct somebody to file on my behalf.
If you can consult around that point, Mr. Shanghala has not said anything about it.
Judge, I think my response in relation to the plea explanation and the pre-trial memorandum applies. Until I'm able to get legal representation from people who know a little bit more about criminal law and criminal law practice than myself, I don't think I want to do it. I will, if I get the lawyer, and I hope to get a lawyer, we'll consider that issue and we'll let you know at the soonest and the earliest possibility.
All right. I think we have canvassed most of the issues, unless on the part of the state you have anything else you want to say? Or Mr. Engelbrecht?
Nothing in particular, but with regards to the issue of disclosure, can Mr. Shanghala, my lord, just because I don't want to be, we don't want to be in verbal talks with him. Can he finally, because he has our emails address, I don't know where he got them, maybe he got them when I was with my boss. Can he finally send us the final list of what he says is not disclosed, because the state has disclosed the docket it wants to rely on during the trial? Can he finally send that email? Then we will accordingly deal with it. Then on the issue of pagination, my lord, the docket, the statements are numbered. A1 up to A, I don't know. They are numbered. That's what the docket does. But I see that Ms. Shanghala had the energy of counting the papers individual, each paper up to 1,600 and whatever. If at that time he had done us a favor by putting the numbers as he was counting the papers, we will not be talking about this anymore. Can he do so? Then he can give us his pagination.
Those little nitty-gritties, I leave them to you, including your issue about disclosure. I have said to Mr. Shanghala, set out what you need disclosed finally, and let's get the response. Then you get a response from the state. But yes, there's a suggestion by Mr. Engelbrecht. I don't know what it would save, but what's your attitude towards it? That at some point between now and August, there must be another status. He was talking about a monthly status.
My lord, that suggestion is sound and it's plausible, because if we leave it until then, nothing will be done. So I think this matter needs to be reviewed.
No, but what do you mean nothing will be done?
Nothing will be done by the accused person, my
The
lord.
order I intend to make, and I am open to any suggestion in regard to that order. My order was going to be very simple. It is ordered that the trial will commence on the 4th of August.
My lord, like the state has always emphasized, this honorable court, that the state has been ready since April 2021, and we've always brought witnesses to this court to commence trial. We are ready to proceed with the trial.
So, like I say, if my order simply states that after hearing the parties and what have you, it is ordered that the trial will proceed on the 4th of August. That is what I intend to do only. And the rest of the consultations you will carry out, because the abiding idea, as far as I am concerned, is if you granted someone reasonable time to prepare for his defense.
Yes.
And if reasonable time has been granted, then that is the position. The trial proceeds.
Yes, my lord.
I am not the one who can grant them the POG applications. I'm not the one who can say to them, well, we have access to your money. I'm not the one who can do all that. And also the fact that, like Mr. Shanghala was saying, some of the applications are not made to me. So, but anyone looking at how this matter is handled, if it doesn't commence in August, I don't know when it will commence, and what impression will be created about the judiciary. So to me, the simple approach, subject to, I was thinking maybe sometime in what? It can be monthly, because
maybe, my lord, there have been, there's been indication that there will be judgments which will be handed down very soon, my lord. Maybe some of those judgments might have an impact in this on this matter. So I was suggesting, and the state is suggesting, that maybe we can meet again in March, towards the end of March. March is when the judgments are coming out, end of March. Maybe mid-April, to see whether those judgments have an impact to the proceedings.
The parties cannot meet on their own.
No, in court, my lord. The court can set a date when.
No, I'm saying, is it not possible for us to fix a date when the parties can meet on their own and come up with, as you did, some report?
That meeting was sanctioned by the order of the court, and there were directives to that effect, my lord. Because the parties on their own, as it is now, it's difficult to agree on anything.
No, to just record the progress, report say mid-April, just to record, or early May, just record what progress has been made in the various matters.
And in those circumstances, my lord, then maybe the court can direct that we meet also under the chairpersonship of the registrar to have this noted down and recorded.
It's part of a function, is it?
Yes, ma'am. She just needs directives to do that.
So my inclination is to say that if there is the parties can meet, say, early May, a date we can agree on, and come up with a report for the information of the court. Early May, what date would you propose, Mr. Engelbrecht?
What about 16 May, Friday?
The court said early May, not mid-May, my lord.
seeing the light that there's public holidays in the beginning of May. That is the reason that I suggested 6th of May. I don't say that we should also not fight about that date. It's only a suggestion. The court is there in order to make a ruling.
Yeah. Any objection to 16 May? I know it's a Friday.
Indeed.
Well, he said it's a Friday. People normally object to Fridays. 16 May.
It's in order.
Yes. Mr. Arondeze.
Consulting the diary, my lord. It's in order, my lord.
It's in order. So the parties to meet and appraise the court of progress right. So my order will be that one, right. I think my order will be to this effect. One, that the trial will proceed on 4 August 2025. Number 2, that the parties shall consult each other to ensure that all obstacles are resolved before all obstacles are, as far as possible, resolved before the resumption of trial. Number 3, that the parties shall meet on 16 May 2025 and report or appraise the court of progress towards the resolution of all outstanding issues.
As the court please.
As the court pleases.
Yes, that is my order. The court adjourns.